morning.
Good morning.
Good morning. I'm embarrassed.
Thank you very much. Good morning, everyone. To our witnesses, thank you very much for sharing your testimony with the committee. We have 9 very distinguished people. If you could keep it to 5 minutes, we appreciate it. We have your written testimony, and we'll certainly look at all of it. Senator Feinstein, thank you yesterday. I thought it was a very good hearing. Asked a lot of good, tough questions that were appropriate. Nominating an Attorney General is no small matter, and I thought the committee acquitted itself well. And Mr. Barr, I think, is a unique individual, and I'm glad the President nominated him. Today, the purpose is to hear from people that have concerns and support, and we're honored that you showed up. If you don't mind, I'll mention who's here, then turn it over to you. Is that okay?
That's excellent.
Thank you. Our first witness will be the Honorable Michael Mukasey, former United States Attorney, former U.S. District Judge, and former attorney, former everything. Yeah, so Mr. Derrick Johnson, President, Chief Executive Officer of the National Association for the Advancement of Colored People from Baltimore, welcome. The Honorable Larry Thompson, former United States Deputy Attorney General, welcome, Larry, good to see you. The Honorable Marc, Morial, is that right, sir? Morial, sorry, President, Chief Executive Officer of the National Urban League. Mrs. Mary Kate Carey, former speechwriter for President George H.W. Bush, and a senior fellow at the Miller Center, University of Virginia. Professor Neil Kinkopf, Professor of Law, Georgia State University College of Law, Atlanta, Georgia. Professor Jonathan Turley, TV star, smart guy. That's enough. Reverend Sharon Washington Risher from Charleston, South Carolina. Mother Emanuel, God bless you. Thank you for coming. Mr. Chuck Canterbury, the National President, Fraternal Order of the Police. I will now turn it over to Senator Feinstein.
Thank you. Thanks very much, Mr. Chairman, and I very much enjoyed your leadership yesterday and look forward to it in the future. So thank you. I'd just like to take a moment to thank our panelists today, and just a few comments, if I may, on the discussion that we had yesterday. Yesterday, many of us from, I think, both sides of the aisle asked Mr. Barr about his legal memo, and that was allowing the special counsel to complete his work unimpeded and making the report at the end of the investigation public. His answers were good. He clearly understands the need for independence and the importance of protecting the department, as well as Mr. Mueller, from political interference. I was concerned by his equivocation regarding the report at the end of the special counsel's investigation. Mr. Barr was clear that he would notify Congress if he disagrees with Mr. Mueller, which I'm grateful for. But his answers on providing a report to Congress at the end of the special counsel's investigation were confusing. When I first asked him about the report, he said he would make it available. However, it seemed to me that as the day progressed, he referenced writing his own report and treating the Mueller report as confidential. I'm going to follow up with him in writing on this. I think it's essential that Congress and the American people know what is in the Mueller report. I first met Bob Mueller when he was U.S. Attorney, and I was mayor in San Francisco. And I know his reputation, I know his integrity, and this is a big report, and the public needs to see it. And with exception of very real national security concerns, I don't even believe there should be very much redaction. So I am hopeful that that report will be made public. And my vote depends on that, Mr. Chairman, because An attorney general must understand the importance of this to the nation as a whole, to us as a Congress, as well as to every American. I also plan to follow up on questions that Senator Blumenthal asked about Roe and whether he would defend Roe if it were challenged. This has always been a critically important issue for me, and I believe the majority of American women. And I very much regret that I didn't get to ask follow-up questions. Mr. Barr's nomination comes at a time when we are very divided on many issues, ranging from immigration and civil rights enforcement to the very independence of the Justice Department. And the witnesses today are going to speak to those key issues. For example, Professor Kinkopf from Georgia University served in the Justice Department's Office of Legal Counsel, and he can speak today about issues he's focused on, primarily presidential authority, as I understand it, and separation of powers. Sharon Risher is an ordained pastor who lost her mother and cousins to gun violence in the horrific hate crime that took place at Emmanuel AME Church in Charleston, South Carolina, and can speak to the importance of enforcing common sense gun laws. We will also hear from two prominent leaders of the civil rights community who could speak to the impact of the Justice Department's policies under President Trump. Mr. Marc Morial, where are you, Marc? Whose sister has been a colleague of ours, and it's great to see you. The President and Chief Executive Officer of the National Urban League now, and Mr. Derrick Johnson, the President of the NAACP. So I welcome, on behalf of this side, I welcome everyone here. Thank you, Mr. Chairman.
Thank you, Senator Feinstein. If it's okay, lead us off. Casey. Oh, sorry, got to swear you in first. Could you please stand, all of you? Thank you. Raise your right hand. You solemnly affirm that the testimony you're about to give this committee is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. All right, General Mukasey. Thank you.
Good morning, Mr. Chairman, Ranking Member Feinstein, members of the committee. It is a tremendous honor, as well as a great pleasure to be here to testify on behalf of Bill Barr to serve as Attorney General. I don't know of any nominee who has had his background and his credentials for this job. Obviously, the job is about a lot more than credentials, but he has done literally everything that you could possibly do, including serving as Attorney General to prepare him. Now, obviously, the Department of Justice is a different place today from the time that he served. It's different from the time that I served. But he's obviously well-equipped to deal with whatever problems he faces. He was with the CIA. He headed the Office of Legal Counsel, which is, I think, the office that attracts, along with the Solicitor General's office, the best legal minds in the department. He headed that office. He was Deputy Attorney General, so he knows how the department runs. And, of course, he was Attorney General. It's impossible to improve on that. Not only what he did, but the way he did it. When he was acting Attorney General, he supervised the liberation of hostages at a federal prison in a way that prevented any casualties, and then followed that up by not taking any public credit for it. That's the kind of person he is, and that's the kind of judgment he has. And as far as pressure from the White House, I mean, he was asked at one point whether he could come up with a theory to justify the line-item veto. And he did a lot of research and found that, well, there was no precedent in our law. There was something that might be called common law going back to about the 15th century. He said there was a Scottish king who had done something that looked like a line-item veto, but of course, that Scottish king, as it turned out, was suffering from syphilis and his mind. And so he would have to call that the syphilitic prerogative if you did it, Mr. President. And so the president decided not to assert the power. That's the kind of judgment he has. That's the kind of humor.
You learn a lot on this committee. That's why I like
it. It was a revelation to me too. It's a terrific story, but it illustrates what he's like. He's not intimidated by questions or by the source of them. When I a couple of months ago when General Sessions was leaving, I thought to write an article pointing out all the good things that he'd done. And I called up Bill Barr to ask whether he would join in that article. He didn't hesitate for a nanosecond. He said he would. He said it was the right thing to do, it was the correct thing to do, and he was glad he had done it. And that, I think, tells you in substance what it is this person is about. He's an honorable, decent, smart man, and I think he will make a superb Attorney General. Thank you very much.
Good morning, Chairman Graham. And is that better? Great. Thank you for allowing me to testify on the nomination of William Barr to be Attorney General of the United States. My name is Derrick Johnson, and since October of 2017, I have had the honor of serving as the President and CEO of the NAACP. Founded in 1909, the NAACP is our nation's oldest, largest, and most widely recognized civil rights organization. The NAACP opposes Mr. Barr's nomination, and I urge every member of this committee to vote against his confirmation. The Senate considers this nomination in extraordinary times. Under the Trump administration, we have experienced the worst erosion in civil rights in modern history. We have seen reversals and rollbacks of longstanding policies and positions that have enjoyed bipartisan support from their creation. We have seen an undermining of both substantive protections and the tools necessary for civil rights enforcement, such as the desperate impact method for proving discrimination and the use of consent decrees to address abuse by police agencies. The next Attorney General of our United States has the opportunity to reverse course and place the Justice Department back on the track to fulfill its historic role of safeguarding our civil and constitutional rights. The Senate must seize this second chance for justice and insist upon an Attorney General capable of independence and willing to enforce our nation's civil rights laws with vigor and resolve. After a thorough evaluation and review of the record, William Barr is not that candidate. Mr. Barr's record demonstrates a lack of strong commitment to protecting the civil and human rights of all Americans. The community served and represented by the NAACP will have a difficult time placing our trust in the Justice Department and, by extension, the American criminal justice system overall, even with the improvements just signed into law with the First Step Act. The Justice Department's enforcement of our voting rights laws is of paramount importance, but the current department has jettisoned protections for the right to vote. It has reversed positions in lawsuits to support voter suppression measures and to purge voters from the rolls. Because Shelby County versus Holder eliminated safeguards under Section 5 of the Voting Rights Act, litigation under Section 2 of the Act is all more important. But the Justice Department has filed no Section 2 claims since this administration has been in place. As the nation experienced rampant voter suppressions throughout the 2018 midterm elections, the Justice Department stood silently as communities of colors across the nation were denied access to the polls. At a time when the Justice Department has abandoned voting right protections, the need for federal enforcement has never been greater. The U.S. Commission on Civil Rights recently reported that voter suppression is at an all-time high and unanimously called on the department to pursue more voting rights enforcement in order to address the aggressive efforts by state and local officials to suppress the vote. Mr. Barr's record on criminal justice is abysmal. As Attorney General, he championed mass incarceration and deprived countless persons of color of their liberty and dramatically limited their future potential. His Justice Department tenure was marked by extraordinary aggressive policies that harmed people of color. He was a general in the war on the crime on drugs that was rooted in racism. He literally wrote a book on the case for more incarceration, which stands in contradiction of the First Chance Act. But William Barr did not and does not recognize racially discriminatory impact of our criminal justice system policies. In 1992, he said, "I think our system is fair and does not treat people differently." And just yesterday, he told Senator Booker, "Overall," and I quote, "the system treats black and whites fairly." That this statement is singularly disqualifying. We need an Attorney General who understands both the history and persistence of racism in our criminal justice system. The government-sponsored inhumanity is inconsistent as it relates to this administration's enforcement of immigration rights. The NAACP, we filed a lawsuit as it relates to DACA. We need an Attorney General who respects the rights of individuals. Finally, and I'm trying to rush through this quickly now, Mr. Barr's recent action make his impartiality on the ongoing investigation into Russia interference in the 2006 election suspects. And for the NAACP, we're very clear. Matters of international questions is not under our purview. But anytime a foreign nation used the worst common denomination in this nation's history of racism to suppress African-American votes and in an effort to subvert democracy, it is a question of national security, and we need an individual who has the independence to stand up and be fair and make sure we protect democracy. Thank you, members of the committee.
Good morning, Chairman Graham, Ranking Member Feinstein, members of the committee. It is my great honor to appear before you this morning in support of Bill Barr's nomination to serve our country once again as Attorney General of the United States. I've known Bill since 1992. I can attest to the fact that Bill has a deep, deep respect for and fidelity to the Department of Justice. Bill will go where the law leads him. In fact, as Attorney General, he did not hesitate, when required by law, to appoint or seek to appoint various special or independent counsel in high-profile matters. He served with great distinction as Attorney General and is highly respected and admired on a bipartisan basis by the career prosecutors and investigators he oversaw in the department. Importantly, Bill knows how to develop much-needed partnerships with state and local law enforcement. He was very successful at this during his tenure as Attorney General and created strong and effective joint task forces across the country to combat white-collar and violent crime. Bill believes that every citizen, no matter where he or she lives, deserves the full protection of the law. Bill also understands that federal law enforcement cannot do the job alone. In 1992, Bill visited my hometown of Atlanta, Georgia, and spoke with members of the Southern Christian Leadership Conference. He said that when cleaning up crime-infested neighborhoods, and I quote, "It cannot be a Washington bureaucratic project. It must be a project where the solutions are found in the community itself." He acknowledged to the Reverend Joseph Lowry that in the past decade, the federal government's anti-crime efforts have relied too heavily on prison construction and not enough on crime prevention. Now, as a former general counsel of a large public company myself, I also appreciate and admire Bill's approach to his work in the private sector. Bill was very supportive of the lawyers who worked with him. He was collaborative with his colleagues. He welcomed input, dialogue, and discussions. He created opportunities for everyone he oversaw to develop and grow in their careers, including many female lawyers and lawyers of color. He was also supportive of diversity in the legal profession. In 2002, the company Bill served as general counsel received the Northeast Region Employer of Choice Award from the Minority Corporate Counsel Association for successfully creating a more inclusive work environment. Finally, members of the committee, I think the most important point I can share with you is that Bill Barr is a person of very high integrity. He led the Department of Justice as Attorney General with an unbending respect for the rule of law. As general counsel of a large public company, he emphasized the importance of complying with all laws, rules, and regulations, and he stood up for his corporate client a world-class compliance program. Bill Barr's integrity is rock solid. He will not, and I repeat, will not simply go along to get along. Last January, he resigned from his position as a director of an important public company board. Bill let his conscience and his integrity guide his decision. As a citizen, I thank Bill for his willingness to return to public service. He is needed, and I look forward to his tenure again and service to our great country as Attorney General. Thank you.
Thank you, Mr. Thompson. Mr. Morial.
Thank you. Chairman Graham, Senator Feinstein, and members of this committee, I want to thank you for the opportunity to testify on the nomination of William Barr to be Attorney General of the United States. I'm Marc Morial and have the pleasure of serving as President and CEO of the National Urban League. Before doing so, I served 8 years as the mayor of my beloved hometown, New Orleans, President of the United States Conference of Mayors, a Louisiana State Senator, a college professor, and a practicing lawyer involved in one of the most important civil rights and voting rights cases to come before the Supreme Court in the 1990s. The National Urban League was founded in 1910. It's a historic civil rights and urban advocacy organization with a network of 90 community-based affiliates, and we have affiliates in every town represented by the members of this committee. We have worked hard and fought for civil rights, justice, and equal opportunity, along with fairness for our entire existence. My illustrious predecessor, the late Whitney Young, was one of the big six of civil rights leaders who worked for the 1964 Civil Rights Act, the 1965 Voting Rights Act, and the 1968 Fair Housing Act. One of our prime missions is to ensure that each of these laws is aggressively, faithfully, and consistently executed and enforced by every president, every Congress, and every Attorney General. That is why I am here today. Mr. Chairman, on behalf of our entire Urban League movement across the country, I urge this committee and the entire Senate, based on a careful examination of this nominee's record, to soundly reject the nomination of William Barr as the next Attorney General of the United States. Let me tell you why. For the past 2 years, the Justice Department has been led by an Attorney General intent on restricting civil and human rights at every turn. This nation needs an Attorney General who will dramatically change course and enforce civil rights laws with vigor and independence. Based on his alarming record, we are convinced that William Barr will not do so. Indeed, in a recent op-ed, Mr. Barr called Jeff Sessions, the architect of these restrictive civil and human rights policies, an outstanding Attorney General, and offered praise for his anti-civil rights policies. It's clear, based on the record, that Mr. Barr intends to follow Mr. Sessions down the same regressive anti-civil rights roadmap. The confirmation of William Barr, who espouses former Attorney General Sessions' policies, would enormously exacerbate our nation's current civil rights crisis. When we submitted comments to the United States Commission on Civil Rights, raising concerns relative to Sessions' actions on various civil rights issues, they were as follows: overturning a memo from former Attorney General Eric Holder aimed at reducing mass incarceration by avoiding mandatory sentencing, disproportionately subjecting African Americans and other minorities to long-term incarceration, abandoning the Justice Department's Smart on Crime initiative, ending the Community-Oriented Policing Services Collaborative Reform Project, a Justice Department program that helped build trust between police officers and the communities that serve, announcing the Justice Department's School Safety Plan that militarizes schools, offering a sweeping review of consent decrees with law enforcement agencies related to police conduct. Nothing but a subterfuge to undermine a crucial tool in the Justice Department's efforts to ensure constitutional and accountable policing. Mr. Barr has a troubling record that tells us that there will be no redress of Sessions' blunders. Last year, after arduous work done by many members of this committee, we passed the first step in the Juvenile Justice Reform Act of 2018, and I want to thank the committee for its support of that. Criminal justice places these achievements at serious risk and gives us no confidence that these hard-fought reforms are going to be carefully executed. Why? As Attorney General, Barr pushed through harsh criminal justice policies, or rather he pursued them, that escalated mass incarceration and the founding war on drugs. His 1992 book, The Case for More Incarceration, argued that the country was incarcerating too few individuals. Barr led an effort in Virginia to abolish parole, build more prisons, and increase prison sentences by as much as 700%. Yesterday, Mr. Barr testified to this committee of his intent to implement the First Step Act. If that is the case, this committee should ask him for a commitment to rescind the guidance that Mr. Sessions issued on May 10, 2017, instructing all United States attorneys to seek the maximum penalty in federal criminal prosecutions. The Attorney General has a duty to vigorously enforce our nation's most critical laws, to protect the rights and liberties of all Americans, to serve as an essential independent check on the excesses of an administration. And we feel the evidence is clear that Mr. Barr is ill-suited to serve as chief enforcer of our civil rights laws. And therefore, we urge this committee, as a part of its deliberations, its duty and its responsibility, to reject Mr. Barr's nomination as our next Attorney General. And I want to thank you for your time.
Thank you, sir. Mr. Carey. Ms. Carey.
Chairman, excuse me, Chairman Graham, Senator Feinstein, and members of the committee, thank you for the invitation to testify today, and I am here to give my enthusiastic support for the nomination of William P. Barr as our next Attorney General. My name is Mary Kate Carey, and I was a White House speechwriter for President George H.W. Bush from 1989 to 1992. In January of 92, I moved to the Justice Department from the White House for the final year of the Bush 41 administration to serve as Deputy Director of Policy and Communications, overseeing the speechwriters and the policy shop, and serving as one of two spokesmen for the then new Attorney General, Bill Barr. When I first started working for General Barr, I was 28 years old. I got to know him very well, as speechwriters do, and quickly learned the way he thinks. I found that Bill Barr has a brilliant legal mind. He knows Mandarin Chinese, and he plays the bagpipes. He's got a great sense of humor and an easy laugh. He is a kind and decent man, a dedicated public servant, and one of the best bosses I've ever had. He is always a gentleman. Bill and I flew thousands of miles that year in a 4-seater prop plane to towns and cities all over America, where he met with local law enforcement leaders, small-town mayors, city council members, victims' rights advocates, criminal justice reform leaders, residents of public housing, prison wardens, federal prosecutors, religious leaders, really all kinds of people from every walk of life. We were often traveling in support of Bill's visionary initiative, Operation Weed and Seed, which sought to remove violent criminals and drug gangs from underserved neighborhoods and then allow grassroots organizations and programs to flourish, bringing hope of a better life to residents through education, opportunity, and stronger civil rights. As we met with people in communities all over America, I saw that Bill was a good listener. He was masterful at drawing out people's concerns, and he had a knack for finding the best solutions on the ground, figuring out what worked in a neighborhood, and then putting the right policies in place. He made sure politics never entered into it. Bill Barr treated everyone with the same respect, whether they were an up-and-coming chief of police, a receptionist at the Department of Justice, or an 80-year-old resident of public housing. I believe this is why Bill Barr continues to be held in high esteem by the career staff and the civil servants at the Department of Justice, and why he was such a successful Attorney General. I also believe that in addition to being good policy, Bill Barr's leadership style is why Operation Weed and Seed continued on for many years after he left office. Everywhere we went that year, we were accompanied by rank-and-file FBI agents, and he was admired by every one of them that I met. More than once, I can remember being in very dangerous situations where the agents were concerned for his physical security. Every time, he was more concerned about my security. The fact that the Attorney General of the United States was more concerned about the safety of a 28-year-old staffer than his own safety tells you volumes about him. Despite his top-notch education and his stunning intellect, Bill Barr is not an ivory tower kind of guy. He went out of his way to build friendships at the department and across the United States, checking in when someone was sick, helping people get jobs, just staying in touch. He and his wife, Christine, came to my wedding, and we have stayed friends for the 27 years since we have worked together. Like President Bush 41 did, Bill Barr has a devoted and wide collection of friends, each of whom think of him as a really good friend. I remember when he was Attorney General at the age of 42, and his 3 daughters were young girls. Despite the long hours he kept, the tremendous amount of travel, and the time spent away from his family, his daughters admired his devotion to the law so much that each of them later went to law school in order to follow in his footsteps. As a mother myself, that too tells me volumes about the way he has lived his life and the example he has given to young people, especially women. It is no surprise to me that he's one of the few people in American history to be asked to be Attorney General of the United States twice. It's an honor for me to highly recommend William P. Barr to you for confirmation. Thank you.
Thank you, Professor Kinkopf. My thanks to the committee for the honor and privilege to appear here today and testify on the nomination of William Barr to be Attorney General. In his testimony yesterday, William Barr minimized his 2018 memorandum on obstruction of justice. He characterized it as a narrow analysis of a particular interpretation of a specific statute. That's true in a sense, but to answer that very narrow question, he elaborated a comprehensive and fully theorized vision of the president's constitutional power. He declared without limit or qualification, and I quote, "Constitutionally, it is wrong to conceive of the president as simply the highest officer in the executive branch. He alone is the executive branch. As such, he is the sole repository of all executive powers conferred by the Constitution. Thus, the full measure of law enforcement authority is placed in the president's hands, and no limit is placed on the kinds of cases subject to his control." That manifesto of an imperial executive has alarming implications for the Mueller investigation and for the whole of the executive branch. First, I wish to highlight 2 implications for the Mueller investigation. William Barr gave reassurances yesterday regarding what he would or would not do. These assurances are beside the point, because on Barr's theory, the power rests with the president. Therefore, the president does not have to ask Barr to do anything. And in his view, the Attorney General and the special counsel are merely the president's hand. Again, a quote. The president needs only ask the Attorney General, "Can I terminate the special counsel's investigation?" And Barr's answer to that question will be yes. This is not speculation or inference drawn from the Barr memo. The Barr memo takes this on very directly. Again, quoting the memo, "Say an incumbent U.S. attorney launches an investigation of an incoming president. The new president knows it is bogus, is being conducted by political opponents, and is damaging his ability to establish his new administration and to address urgent matters on behalf of the nation. It would be neither corrupt nor a crime for the new president to terminate the matter." Well, President Trump has told us that that is exactly how he regards the Mueller investigation. Next, there was a great deal of discussion around the release of Mueller's report. First, it is clear that Barr does not mean that Barr takes the DOJ regulations to mean that he should release not the Mueller report, but rather his own report. Second, he reads DOJ regulations and policy and practice to forbid any discussion of decisions declining to indict, declination decisions. In combination with the DOJ view that a sitting president may not be indicted, this suggests that Barr will take the position that any discussion or release of the Mueller report relating to the president who again cannot be indicted, would be improper and prohibited by DOJ policy and regulations. I wish to close by noting one consequence of the Barr memo's theory of executive power that extends outside the Mueller probe. The memo asserts that the president has, and I'm quoting again, illimitable discretion to remove principal officers carrying out his executive functions. This would mean, for example, that the president may order the chairman of the Federal Reserve not to raise interest rates, and to fire the chairman of the Federal Reserve if the chairman refuses to follow that order. The independence of the Federal Reserve, the SEC, the FEC, the FTC, the FCC, the dozens of independent administrative agencies are unconstitutional under Barr's theory of executive power. This in spite of the fact that for over 80 years, the Supreme Court has consistently upheld the constitutional validity of the independence of those entities. Mr. Barr's theory of presidential power is fundamentally inconsistent with our Constitution and deeply dangerous for our nation.
Professor Turley.
Thank you, Senator Corrin. Also, allow me to thank Chairman Graham, Ranking Member Feinstein, all the members of the committee for the honor of speaking to you today. I've known General Barr for many years in my capacity as both an academic and a litigator. I actually represented him with other former attorneys general during the litigation leading up to the Clinton impeachment. I can think of no better person to serve in this position and lead the Justice Department at this critical time. I come to this as someone that holds different views of the Constitution from General Barr. I am unabashedly a Madisonian scholar, and I have always admitted in testimony that I favor the legislative branch in fights with the executive branch. I also been a critic of the expansion of executive power. My default is in Article 1. General Barr's default is Article 2. He tends to take a robust view of executive authority. Despite our different defaults, however, I've always admired him. I have always found him to be one of the most knowledgeable and circumspect leaders in the United States when it comes to constitutional history and theory. Now, I have already submitted written testimony addressing the 1989 and 2018 memos. I respectfully disagree with my friend Neil, even though I found many of the things he said very compelling. We disagree on both what General Barr has said and also the implications of his views. But ultimately, this committee has a difficult task, regardless of the resume of a nominee. You have to try to determine what is the person's core identity and values. For me, that question has always come down to a rather curious and little-known fact about the seal of the Attorney General that sits underneath the Attorney General whenever he speaks. It has the familiar image of a rising eagle with the olive branch and the 13 arrows and talons. But under it is actually a Latin legend that we continue to fight about how that legend was put on the seal. What we know is that it appears to be derived from how the Attorney General was introduced to the Queen. The British Attorney General was introduced as one who prosecutes for Our Lady the Queen. That phrase was clearly adopted by someone. There's a huge debate about who or when or even why, but they made one change. It would not do to use that language. So they changed the last words to Dominia Justitia, Our Lady Justice. It wouldn't do for the Attorney General to litigate or appear on behalf of any leader. The Attorney General appears on behalf of the Constitution, not the President. I know that Bill Barr understands that distinction. He has said so yesterday. He has maintained that position through his whole career. He has a record of civic leadership, not just at the Department of Justice, but in this very position. He's only the second person ever to be nominated to fill that position twice. There are few nominees in history, as General Mukasey said, who has the resume that Bill Barr has. I won't go into depth about the discussion of the memo that Neil was talking about, other than to say this. I do go into it in my written testimony. As Deputy Attorney General Rod Rosenstein said, it is not uncommon for former justice officials to share their views about issues that they believe concern the department. Indeed, General Barr wrote to other justice officials about the prosecution of Senator Menendez. He had no connection with Senator Menendez, no interest in that case. His interest was the theory of prosecution being used against Senator Menendez, that he was concerned swept too broadly under the criminal code. The 2018 memo is vintage Bill Barr. It is detailed, it is dispassionate. It's the work of a law nerd, and that's what he is. He's a law nerd. I should know because I'm a law nerd, and I teach with 80 other law nerds. When people are suspicious, why would anyone write a memo this long spontaneously and send it to anyone? That's because you don't know law nerds. Okay? We write these memos so that we don't follow strangers on the street trying to talk about the unitary executive theory. Indeed, I think the best thing we could do for Christine and the family is to reincarcerate Bill on the 5th floor of Main Justice, where he can talk about this all day long. Now, the dispute about that obstruction provision is a real one. I'm a little taken aback by the criticism. From a civil liberties standpoint, I've been critical of the expansion of the obstruction theory. It sweeps too broadly for me. And as a criminal defense attorney, I've been critical of it for a very long time. The issue that he was raising is a real one. He raises it from the Article 2 standpoint. Some of us have raised it from the civil liberties standpoint. What he really is arguing is not that the president can't be prosecuted. He says exactly the opposite. He says the president can be charged with federal crimes in office. He believes the president can be charged with obstruction in office. So he says the diametrically opposed thing to what many people are saying about him. What he believes is, just as Confucius said, that the start of wisdom is to call things by their proper names. He wants to call this by its proper name. If the president commits a crime, he wants that crime to be defined. He does not say, by the way, that that same conduct cannot be another type of crime. He was only talking about the residual clause of 1512. Those were fair questions about statutory interpretation. I don't agree with everything in his memo. I've said that publicly. Well, I disagree in some of his conclusions, but I wholeheartedly agree with him that this is a serious problem and it has to be defined. Now, ultimately, I believe if you read his testimony, you will find that he is more measured than some of my friends have suggested. Even Clinton's own former appointees, like James Clapper, said that yesterday he went as far as he could go as Attorney General, giving assurances. But this is a historic moment for the Justice Department. I hope it doesn't pass. They need this man, and they need it now. I brought my children today, Aiden and Maddie, because I think that they really should be here. I suspect they're here because they heard that Senator Feinstein was giving out junk food to kids. But I hope that they will also understand the historic moment for what it is. And I thank you for the honor of being part of this.
Thank you, Reverend Risher.
Good morning, Chairman Graham, Ranking Member Feinstein, and members of the Senate Judiciary Committee. It is my honor to appear before you today to testify on the nomination of William Barr to be Attorney General of the United States. My name is Reverend Sharon Risher, and I live in Charlotte, North Carolina. My life, like so many other people's throughout this nation, has been forever changed by gun violence that is preventable with effective enforcement and common sense safety laws. On Wednesday, June 17th, 2015, is the day that my life changed. As a hospital trauma chaplain, I have worked and experienced grief and tragedy and pain and loss as I worked with patients and families to comfort them. But that night, I was the one in need of comforting when I received a telephone call that no American deserves to get. My beloved mother and two of my cousins had been shot and killed in the church along with 6 other parishioners at the Emmanuel African Methodist Episcopal Church in Charleston, South Carolina. In the Charleston community which I was raised, when the doors of the church was open, my family was in the pews. That Wednesday was no different. A young white man entered the church at the beginning of the Bible study. In the spirit of our faith, he was welcomed in by the congregation and sat near the pastor. After studying the Gospel of Marc, they held hands and bowed their heads and closed their eyes and held hands in prayer. That was the final moment for many in that church. That day, that young man pulled out his gun and started firing. Some ran, some hid under tables, but they were gunned down. A house of worship is supposed to be a refuge from the storms of everyday life. But that young man robbed my family and the 8 other families of their loved ones. 5 people survived. 5 people have to live every day with that tragedy in their hearts. After the massacre in Charleston, I struggled to answer why my loved ones and so many others had been killed. I was disturbed to learn that the shooting was premeditated and driven by hate. The shooter targeted parishioners at Emmanuel simply because of the color of their skins. Along with so many Americans, I was baffled at how such a hateful man was able to get his hands on a gun. We later discovered that a loophole in our gun laws allowed the shooter to obtain the gun used to murder my mother and my cousins and the 6 others in that church. That loophole allowed hatred to be armed to kill. The person that killed my family members should have not been able to buy that gun. The National Instant Criminal Background Check System was designed to keep guns out of the wrong hands, including criminals, domestic abusers, and unlawful users of controlled substances. The Charleston shooter had previously been arrested for drug possession, something that should have blocked him from obtaining a gun under our existing laws. Yet, he was able to legally purchase one because of a loophole in the federal law. You see, if the FBI does not finish a background check within 3 days, the sale can proceed regardless of whether the check had been completed. And that's exactly how the man who killed my family exploited a loophole and got his gun. And he's not the only one. The FBI reported that in 2017 alone, gun dealers sold at least 4,864 guns to prohibited people before the background checks had been completed. Those nearly 5,000 sales were primarily made to felons, domestic abusers, or, like the man who killed my family, unlawful users of controlled substances. A strong background check system is the foundation for common sense safety laws that keep guns out of the hands of the wrong people. We can stop hate from being armed, but we need background checks on all gun sales, and law enforcement needs enough time to complete the background check. Each day, I wake up motivated to ensure that hate will not win. As a member of the Everytown Survivor Network, I share my story to put a human face on our nation's gun violence crisis. Our community of survivor advocates for change to help ensure that no other family faces the type of tragedy we have experienced. If he is confirmed as our nation's next Attorney General, Mr. Barr will serve as our nation's top law enforcement officer in a position of great power and influence. I hope he will make it a priority to prevent gun violence and work with Congress to update our laws and close loopholes that enable guns to get in the wrong hand, just like that young man, filled with hate, murdered my family. 9 lives were cut short in Charleston. Today, I say the names of my mother and my cousins and the 6 other people to honor them in this most sacred place. My mother, Mrs. Ethel Lance. My 2 cousins, Mrs. Susie Jackson and Tywanda Sanders. My childhood friend, Myra Thompson. The pastor of the church, Reverend Clemente Pinckney. Reverend Daniel Simmons, Reverend Sharonda Coleman Singleton, Mrs. Cynthia Hurd, Reverend DePayne Middleton Doctor. I pray that whenever you hear their names, you feel empowered to help bring about change. Thank you for listening, and I will answer any questions that you have.
Good morning, Mr. Chairman, Ranking Member Feinstein, and distinguished members of the Committee on the Judiciary. I am the elected spokesperson of more than 345,000 rank-and-file police officers, the largest law enforcement organization in the United States. I'm very pleased to have the opportunity to offer the strong and unequivocal support of the FOP for the nomination of William P. Barr to be the next Attorney General of the United States. In my previous appearances before this committee, I've been proud to offer the FOP's support for a number of nominees, with the expectation that they would be good leaders, that they would serve our country honorably and effectively. In this case, however, there's no need to speculate whether or not Mr. Barr would make a good Attorney General, because he's already been a good Attorney General in the administration of President George H.W. Bush. He had the experience, the knowledge, and the ability to lead the department then, and he certainly does now. Mr. Barr's career of public service began as a clerk for a judge on the U.S. Court of Appeals for the District of Columbia, and he served a short tenure in the Reagan White House. He then joined the Bush administration as Assistant Attorney General for the Office of Legal Counsel in 1989. President Bush took note of his leadership, integrity, and commitment to law enforcement and promoted him to Deputy AG in 1990. In 1991, he was named Acting Attorney General and was immediately faced with a public safety crisis. At the Talladega Federal Prison, more than 100 Cuban inmates awaiting transportation back to their country, staged a riot and took 7 corrections officers and 3 immigration and naturalization employees hostage. In the first hours of the standoff, General Barr ordered the FBI to plan a hostage rescue effort. The Cuban inmates demanded that they be allowed to stay in this country and released one of the hostages. Over the course of the 9-day siege, it was clear then that negotiations were failing. General Barr ordered the FBI to breach the prison and rescue the hostages. They were freed without any loss of life, and the incident was ended because of General Barr's decisive action. Following the successful resolution of this incident, President Bush nominated him to be U.S. Attorney General. The Committee on the Judiciary reported his nomination unanimously, and the Senate confirmed him as the 77th Attorney General. Through his service and his actions, he demonstrated he was the right man for the job. The FOP believes he is the right man for the job again today. 2 years ago, just after his inauguration, President Trump issued 3 executive orders on law enforcement and public safety. The first directed to the federal government to develop strategies to enhance the protection and safety of our officers on the beat. The others created a task force on crime reduction and public safety and for the development of a national strategy to combat transnational criminal organizations, trafficking in human beings, weapons, and illicit drugs. Mr. Chairman, during his tenure as Attorney General, Mr. Barr directed and oversaw a similar transformation at the Justice Department by refocusing its resources, by making crimes of violence, particularly gang violence, a top priority for law enforcement. I submit to this committee that Mr. Barr is the perfect person to complete the work begun by General Sessions with respect to focusing federal resources to fight violent crime, because he's not only done it before, he's done it as the Attorney General. President Trump has clearly made law enforcement and public safety a top priority. His nomination of William Barr to be the next Attorney General demonstrates that these priorities have not changed. We know Mr. Barr's record and abilities, as well as his prior experience in that office. The FOP shares his views, and we are confident that Mr. Barr will once again be a stellar top cop. We believe the President made an outstanding choice, and for Mr. Barr to return to public service as the Attorney General of the United States will serve this country well. The FOP proudly offers our full and vigorous support for this nominee, and we urge this committee to favorably report this nomination just as you did in 1991. Thank you for the opportunity to testify. I'd be glad to answer any questions.
Thank you all very much. I appreciate your testimony, and I'll get us started here quickly. Reverend Risher, thank you for your coming up here and sharing your loss and your story and your hurt. Some comfort, I hope, is that Mr. Barr said if he is the Attorney General, he'll pursue red flag legislation that I'm working on with Mr. Blumenthal and others that would allow law enforcement, if they have appropriate information, to go and deny somebody a gun who is showing dangerous behavior. I think that's a real gap in our law. Most of these cases, people are screaming before they act, and we're just not listening. The guy down in Florida did everything but take an ad out in the paper, I'm going to kill somebody. And it would have been nice if the police would have had a chance to go in and stop it before it happened. As to Dylan Ruth, who is facing the death penalty in South Carolina, he applied for a gun in West Columbia, South Carolina. The system said he had just been arrested. During the 3 days of looking into the arrest, he had not been convicted. The FBI agent called the wrong solicitor's office. There's 2 counties in Columbia, and they did not find out the fact he had admitted to being possessing and using a substance that would have kept him from owning a gun. So we need to reform the laws, but that was sort of a mistake more than it was a loophole. Mr. Turley, thank you very much for what you had to say. The special counsel regulation is 28 CFR 600.8. It says at the conclusion of the special counsel's work, he or she shall provide the Attorney General with a confidential report explaining the prosecution or declination decisions reached by the special counsel. So you think Barr will take this report seriously if given to him?
Absolutely.
Okay. It also says the Attorney General will notify the ranking member and chairman of the Judiciary Committee in both bodies. Do you think he'll do that?
Absolutely.
Okay. It also says, to the extent consistent with applicable law, a description and explanation of instances, if any, in which the Attorney General concluded that a proposed action by a special counsel was so inappropriate or unwarranted under established departmental practices that it should not be pursued. So under this regulation, if Mr. Mueller recommends a course of action and Mr. Barr says, I don't think we should do that, he has to tell us about that event. Do you agree that's what the regulation requires?
Absolutely.
Do you believe he will do that?
Absolutely.
Okay. It also says the Attorney General may determine that public release of these reports would be in the public interest to the extent that the release would comply with applicable legal restrictions. Do you think he will be as transparent as possible?
Yes, and he said that, and I could add one thing to this, Mr. Chairman. The committee pressed him on what he meant by that. I know that Ranking Member Feinstein also raised this in her comments. But as James Clapper and other people noted yesterday, there's only so much that, as far that a nominee can go. You can't ask that he satisfy ethical standards when asking him to commit in advance to release of information that he hasn't seen yet, because part of his duty is to protect things like Rule 6C information, grand jury information, and the derivative information, privileged information. He is duty-bound to review that. So the only thing a nominee can say is that he is going to err on the side of transparency and try to get as much of the report to Congress as possible.
Based on what you know about Mr. Barr, should we take him at his word?
Absolutely. I have never known Bill Barr, in all the years that we have known each other, I've never known him to be anything but honest and straightforward. The last time he came in front of this committee, the chairman of that committee, one of your predecessors, praised Barr. He said that this is a sort of a throwback to what committee hearings used to be like, where the nominee actually answered questions. He's a very honest person, and if he said that he's going to err on the side of transparency, you can take it to the bank.
Okay. So, Mr. Johnson, thank you for coming today. I listened to your concerns about Mr. Barr. I voted for Holder and Lynch. Do you think I made a good decision voting for them to be Attorney General?
I do.
Why?
I think their presentation before this committee was honest, direct, but more importantly, they committed to protect our democracy. For African Americans, protecting democracy is to also regularly enforce efforts to ensure that all citizens can cast their ballot.
Right.
They committed to that, and they demonstrated that while they were in office.
Okay, and you believe Mr. Barr will not be committed to that?
I have serious reservations and concerns.
Okay.
Those concerns first start with this administration, their lack of enforcing Section 2 of the Voting Rights Act.
How much of it is about this administration versus Mr. Barr?
In many ways, it's difficult to separate the two.
So I just want to suggest something to you. There's a lot of concerns I had about the Obama administration. I will not bore you with my concerns. But I thought he chose wisely with Mr. Holder and Ms. Lynch because they have differences on policy than I, because I'm a Republican. But I thought they would be good stewards of the law and they would be fair arbiters of being Attorney General. It never crossed my mind that I would vote against them because I have policy disagreements. If that's going to be the new standard, none of us are going to vote for anybody on the other side. So thank you for your input.
But if I may, Mr. Chair?
Please.
Going beyond policy disagreement, this nation has had a long history of discriminatory practices, particularly in the criminal justice system. And anytime we have a nominee to come before this committee who truly don't appreciate the disparities in the criminal justice system, as he stated yesterday, that goes beyond policy disagreement. That goes towards whether or not we understand that equal protection of the law should be afforded to all citizens.
I want to make sure you understand what he said, because I remember Senator Booker asked him, and he says, yes, the crack cocaine sentences were disproportionate to the African-American individual, and that's why we changed the disparity between powder cocaine and crack cocaine. He acknowledged that, but in 1992, he thought the biggest victim of rampant violent crime were, you know, low-income, mostly minority communities. So I don't buy what you're saying about him not understanding their differences and how one group is affected, particularly in the drug arena. So I think what he was trying to do is talk about crime. But here's what's perplexing to me. The NAACP has been in the fight for social and racial justice for a very long time. And I don't know how we got here, but you do a scorecard every year. And in 2017, every Democrat got 100%. I got 22%. Grassley got 11. Cornyn got 11. Lee got 11. Cruz got 11. Sass got 6. Ernst got 11. Kennedy got 17. Tillis got 11. And Crapo got 6. There's a disparity here. I hope you think that I'm, because I disagree with your scorecard rating, that I'm not a racist, and I certainly don't know how to close this gap.
So
I'd like to.
Right. So the NAACP, we're a nonpartisan organization. Our scorecard is not based on political parties. Our scorecard is based on our agenda.
Well, how do you explain the differences?
If you allow me, our agenda is set by the delegates from across the country. And we're very clear that discrimination should not be a part of,
how many of them are
any
Republicans?
agenda. Excuse me?
How many of them are Republicans?
We don't determine how many members are Republicans. We have Republicans among our membership on our national board.
I don't want to.
But if you allow me to explain
Please,
the report card, right? And so we establish our agenda not based on political parties because we understand that political parties are nothing more than vehicles for agendas. And as many African Americans were members of the Republican parties before the 1965 Voting Rights Act, many African Americans may decide their agenda based on the party's platform. And if party platforms align with the needs and interests of our communities, then they would vote for a platform that support their needs, whether it's access to quality public education, ensuring that all African Americans and Americans can cast a fair ballot, fair housing policies, making sure we have true tests to determine disparate impact. Those are the issues we are concerned about. Those are not partisan issues. Those are policy issues. And individuals who run under party labels, they decide based on the platform that they believe which party label they run under. We don't make partisan decisions. We make policy decisions, and it's informed by members across the country. Some are Democrats, some are Libertarians, some are Republicans.
You may not think that you're making, that your agenda is party neutral. All I can tell you is somebody who wants to solve problems. It's pretty odd to me that every Democrat gets 100%, and I do the best as a Republican getting 22. Maybe the problem's all on our side. I don't think so. I think the agenda that you're pursuing in the eyes of conservatives is not as good for the country as you think it is. And it's got nothing to do about Republican and Democrat. It's more it has to do about liberal and conservative. You got to ask yourself, why does every conservative on this committee, the best I can do is to get 22?
Mr. Chairman.
Well, I think it's a different question. I think the members of the Republican Party should ask yourselves, are you willing to be expansive enough and inclusive to ensure the rights of individuals, despite their racial background, their interests are met, not based on conservative or liberal tendencies, but based on those individuals' needs and the interests that they advocate for.
Will you ask yourselves why I can't get better than 22% from conservatives?
Yeah, sure. We can go down each one of the policy agendas, and we can go through each one of them, and we can make a determination.
I want to
That's a good discussion.
I want to sharpen this discussion because I think it's an important discussion, and give you what concerns me when it comes to this entire discussion. This is about whether the nominee is going to aggressively, faithfully enforce the civil rights laws. And let me give you a couple of facts.
Can I ask you one question? You give me all the facts you want.
Yeah.
Name one Republican that you would support.
I'm not here to talk about Republicans and Democrats. I supported him when he was a Democrat.
I just can't think of a better person to pick than Mr. Barr if you're a Republican. So I don't know who's going to do better than him in terms of experience, judgment, and temperament. So if this guy doesn't cut it, I'm at a loss of who we can pick.
Well, but Senator, let me make my point because I want the committee to be extremely clear on this, and I want to cite two examples. Attorney General Sessions, and we have to talk about his record because the question for us is whether Mr. Barr is going to continue the policies of Attorney General Sessions when it comes to enforcing civil rights laws. In 2 instances, Attorney General Sessions, in his first days and months in office, had the Justice Department change sides in the middle of an important civil rights case.
Elections matter.
Texas, but Senator, the enforcement of the law does not. The enforcement of civil rights laws is neutral when it comes to elections. So what Attorney General Sessions had the Justice Department do is switch in the Texas voter ID law after the judge had made a finding, preliminary finding, that the Texas voter ID law was discriminatory. You know what it would be an example of? If Drew Brees or Tom Brady, after leading his team to a lead, went in at halftime and came out with the jersey of the other team on. In the middle of the case. Secondly, in the Ohio voter purge case, the same thing occurs. Why did the Justice Department, without any discussion with the Congress, without any discussion with the civil rights community, switch sides miraculously and immediately? That should not have anything to do with who wins an election.
I will say this. I could have given you 100 examples of where Eric Holder and Loretta Lynch had a different view of a statute or a policy than I did. But if you don't expect elections to matter, that's a mistake. The policy differences we have are real. To expect Trump to win and everything Obama did stay the same is unrealistic. All I'm asking is that let's look at qualifications, because a Democrat will win one day, and they will nominate somebody with a completely different policy view than I have. It will be a very simple decision. If I can find a difference, I'll vote no. The question I'm trying to ask the country is, do you expect quality people to be chosen by the other side who has differences with you? If the answer is yes, then Mr. Barr is as good as it will get.
Well, you know, Senator, lots of us thought you were going to be nominated as Attorney General.
Would you have supported me?
Hey, guess what? We'd have had I know we'd have had a discussion, and I wouldn't close the door on that.
Well, I appreciate that.
So I'll say that.
I don't think
We
I'm
thought you were
nearly
gonna
as
be
qualified
nominated.
as Mr. Barr. I don't think I could hold a candle to him. But the fact you said that about me, I appreciate the hell out of it. And let's see if we can find a way to get me above 22%.
Let's work on it.
All right. Change a few policies.
Reverend Risher, I just want to say something to you personally. I will never, ever forget your words, your emotion, the truth you spoke, and your feelings. And I just want you to know that there's so many of us that now know so many victims of guns in this country that we will continue to fight on to change this environment. So just know that. And I'm so happy. You're one of the best witnesses I have ever heard, and your words will not be lost. I hope your family is in a better place. Thank you.
Thank you so much.
Thank you. Mr. Kinkopf, if I may, Mr. Barr has stated that the memo that I spent all day reading and is very complicated has stated that that memo was narrowly focused on obstruction of justice. However, Mr. Barr's arguments outline broad presidential powers. Please explain how his view of executive authority could impact the Mueller investigation.
Okay. Well, in any number of ways, I think most fundamentally is his claim, without limit or qualification, that the president is the executive branch and that therefore all executive power is vested in the president personally, that the president can personally exercise that power, and not leaving this to speculation or to chance, the memo specifically says that the president can control any litigation, any prosecution or investigation, including a prosecution or investigation of the president personally and the president's family members. And further, it says that the Attorney General, the special counsel, anyone serving under the President is merely the President's hands.
Well, it was certainly a case for the unitary executive and the all-powerful central figure. There's no question, I think, about that. In my mind, the question is, you know, how does he really mean this? And it's hard if you don't know a man and he's here and he's in front of you for the first time and you meet him. It's very hard to make those judgments. He's obviously very smart. He was Attorney General before. No one can say he isn't qualified. The question comes that we're at a time and a place where there are a lot of other subjects that are important. He has stated that his memo was narrowly focused. Mr. Turley, we've got a defense counsel, I guess. How do you see this? That same question I asked Professor Kinkopf.
No, it's a fair question, and Neil and I agree actually on a great deal because we both have really difficulty with the expansion of executive authority. We're both critics of aspects of the unitary executive theory, but we disagree on the Barr memo. I think it was narrow. I mean, he says in the memo that he believes the president can be charged with obstruction in office. He believes that the president can be charged with other crimes in office. And where I disagree with Neil is that it is true that he says in his memos that the Constitution doesn't limit the power of the presidency that in these regards, and that's demonstrably true. It's not in the Constitution. There are not those limitations. But he has said repeatedly in writing and before this committee that he believes that a president can be charged for acts in office. He also believes that if the president misuses his authority, it can be an abuse of power, and it could be a violation of his duty to faithfully execute the U.S. laws.
Well, it doesn't mean that Mr. Mueller could recommend indictment of the president and Mr. Barr could disagree.
On that, I'm not sure where Neil is.
That's an esoteric question, I understand, but I think it's along the line of your thinking.
Yeah, and I agree with some of the senators on this committee. I've always said that a sitting president could be indicted in office. I disagree with the OLC memos in that respect. Would General Barr change that position? My guess is he probably would not. Would the special counsel ask for a change? My guess is probably not. It's not really. If you look at the history of both of these individuals, they're not likely to either disagree or move for a change.
In this, let me ask both of you or anyone that wants to answer this. This memo and the whole concept of the unitary executive, all powerful, I think has never been better expressed in a contemporary way than I've read it in this memo. And I was thinking last night, obviously, Mr. Barr is qualified. He is bright. He is capable. But it's hard for me to understand why, with our Constitution, our Bill of Rights, why we want somebody that is all-powerful in every way to take these actions.
So, Senator,
I think my question was not well stated, but I think you got the gist of it.
Right. Senator, I think we don't. So I would agree that William Barr is amply well qualified by virtue of experience, by virtue of intellect, by virtue of integrity. I have no doubt that he will stand up for his vision of the Constitution. And that's what I find so troubling, because his vision of the Constitution is so expansive and alarming with respect to the president's power, right? That's why I've quoted it. It's not my characterization. He says directly, the president alone is the executive branch. He speaks repeatedly through the memo of the president's illimitable powers. And while it's true that the Constitution doesn't specifically authorize Congress to limit the president's prosecutorial discretion by its text. It also doesn't, by its text, give prosecutorial discretion to the president. All investigation and prosecution is done pursuant to laws enacted by Congress. And within that authority to enact those laws is the authority to establish the parameters on that power. You do that, and you do that validly and legitimately. The Supreme Court has said that repeatedly. And what is so alarming about the Barr memo is that it reads the Constitution in a way that frees the president from those constraints.
This is where we do disagree, and I thought the question was presented quite well because it does isolate where we depart. And that is, first of all, even though I don't like the unitary executive theory, there are many, many judges and lawyers who believe fervently in it. Also, there's not one single definition of that theory. There's a sort of a gradation of where you fall on that. Bill Barr actually disagrees with the position of the Trump legal team. He expressly said that they're wrong, that it doesn't curtail a president's authority to prosecute him in office. So he's not at the extreme on this. But the other thing I wanted to note is that I think where Neil and I disagree is that Neil is taking Barr's statement as to the constitutional footprint, the mandate of the Constitution, which does not have limitations in these areas, from how they would apply, where he said very clearly the president cannot do whatever he wants. There are consequences. He could even be prosecuted.
Thank you. Thank you, Mr. Chairman.
Senator Hawley.
Thank you, Mr. Chairman, and thanks to all of you for being here today.
That was interesting.
Yeah, really.
General Mukasey, can I start with you, I think, and thank you, General, for your long service, both as Attorney General, distinguished service, and on the federal bench. As a former Attorney General yourself, of course, you know the office firsthand. You have done this job. You've done it in a time of great national security peril for this country. You referenced in your opening statement the qualifications that Bill Barr would bring to this job and the advantages in some ways he would have having done the job already. Can you just speak more to that? I mean, I imagine if you were coming back to be Attorney General again, there are things you would do differently, knowing the job as you do now. So can you just elaborate for us why you think that his prior experience is a major plus?
Well, quite simply, he doesn't have and won't have the same steep learning curve that I had coming out of Article 3. He doesn't have to do DOJ 101 and learn how each office runs, and he doesn't have to learn how they interact. He doesn't have to contemplate from ground zero the powers and the authority of each of the offices under him. He's seen it and done it. But I don't want to overstate the degree to which his experience prepares him. Obviously, we're living in a different time, and the issues are different. He's going to have to face that. But he's going to be able to devote 100% of his energy to doing that rather than learning the basics. That's what I meant. If I can go back, if I may, to the conversation you were just having about the president's powers. I do happen to believe in the unitary executive, unlike the other two folks. And this is not a question of religious belief, and it's not some quirky attitude. The Constitution says, beginning of Article 2, the executive authority shall be vested in the President of the United States. It doesn't say all except a little bit of it. It doesn't say most of it. It says the executive power. That means all of it. Obviously, the president can be removed not only for crimes, but also for using his conferred powers in an improper way. And the president runs the political risk of having that happen every time he does something that comes close to the line or goes over the line. And that, I think, is the constraint. And it's so far been a reliable constraint. Everybody says that, well, he could remove Mueller. Perhaps he could. But guess what? He hasn't done it yet. And there's good reason why he hasn't done it yet, because the earth would open up and swallow him. We all know that. So I think that's really what's at stake here, the political risk.
General Mukasey, just staying with that point, is I think this is interesting, and again, as someone who's held this office and advised presidents and enforced the law, as you have, you're familiar with Mr. Barr's views on executive authority, Article 2 power. Do you think that those are out of the mainstream?
I do not.
Do you think that they're inconsistent with the Constitution?
No, they are faithful to the Constitution. That's what he is faithful to.
Go ahead. I mean, explain to us why you think it's important that the fact that Article 2 vests all executive power in one person, in the President of the United States, why that's an important concept and important for the functioning of our constitutional system.
It's important because it assures that there is going to be political responsibility lodged someplace. It assures that when people in the executive act in a particular way, that they and the person at the top can be held responsible for what they do. People spoke about independent agencies. They are, in a sense, independent in the sense that they don't relate to other agencies, but they're not a fourth or fifth or sixth branch of government. They are within the executive, and it's important that that be true, because there's got to be somebody responsible for how that functions. The people who wrote the Constitution were, if they were afraid of anything, what they were afraid of was their experience under the Articles of Confederation, where there had been a very weak executive and no ability of the government of the country to defend itself. They needed a strong executive, and that was the Constitution they wrote. If we want to amend it, I guess we can. But
tell me this:
that's what's there.
In your view, the vesting clause, the fact that the vesting clause in Article 2 gives the executive power to a president of the United States, a single president of the United States, does that mean that this individual, that the president of the United States, has illimitable power or is able to do whatever he or she may please?
No, because the one duty that it imposes on the president, and this is also imposed by the Constitution, is to see to it that the laws are faithfully enforced. That is just as much a constitutional duty as any other. And if he doesn't do that, he's subject to removal. That is his obligation. That is his really principal obligation.
Thank you very much. Mr. Canterbury, I want to ask you, you lead the Fraternal Order Police. It's incredibly important to me that the top law enforcement officer in this country, the Attorney General, have the confidence in the men and women of our nation's police forces. Can you just elaborate for us what the most important issues were for your members that led your group to support former Attorney General Barr, hopefully future Attorney General Barr, for this nomination?
One is his past experiences, his job that he did in the prior administration. We've been around a long time, and we knew him then. We saw the way he administered the Department of Justice, the way he worked with state and local law enforcement. Regardless of who leads the Justice Department, if there's no outreach to state and local law enforcement, then it really doesn't transcend to the state and local level. Under former Attorney General Barr, he did just that, and as General Sessions did, and as Eric Holder did. You know, we've testified for a number of nominees over the years. Eric Holder had a tremendous reputation as a prosecutor in the law enforcement community, so I sat at this very table and testified for him. It's all based on the experiences that they had as either U.S. attorney, federal judges, or even in private practice.
Why do you think it's so important that to police officers that they have a capable, effective, experienced Attorney General?
Just the administration of justice. I've heard the complaints about the Civil Rights Division, but we know from experience that a collaborative effort, rather than consent decrees, have real consequences in the cities. For instance, in Cincinnati, when the administration entered a collaborative agreement and all parties were at the table, we came out with a plan to help bring that city back together. In the last election in Cincinnati, the FOP endorsed a member of the NAACP to be a city council member. That would not have happened if they had not got to know each other, sitting around a table, working together for the betterment of that community. We favor the collaborative approach for consent decrees because they're real circumstances other than just say, you will do this or you know, we won't leave. Then they do it, and then obviously nothing ever changes. But when it's collaborative and everybody's at the table, we saw real change.
Thank you very much. Thank you, Mr. Chairman.
Thanks, Mr. Chairman. Reverend Risher, thank you. Thank you for your testimony. Thank you for your touching words about that telephone call. I'll remember that because so many people receive that telephone call about people that they love who are victims of gun violence. I'm honored to represent the city of Chicago. Sadly, we have a lot of gun violence and a lot of victims, families just like yours who will never, ever forget as long as they live what happened. I often think about what I'm going to say to them. I stopped saying, let me tell you about a new law that I've got in mind. I've stopped saying that because we don't pass laws on gun safety in this United States Congress. We don't. And it's unfortunate. We don't even pass the most basic and obvious things about background checks. We just can't do it, politically can't do it. A lot of reasons for it I won't get into here. But I'll just suggest to you that, as fate would have it, sitting to your left is gentleman Mr. Canterbury, representing 345,000, did you say, members of the police who put their lives on the line every single day. And those guns on the street are aimed at them many times. And if there's ever a moment when the victims of gun violence like you, Reverend Risher, and Mr. Canterbury and the police ever come together on an agreement, on a piece of legislation, call me immediately. It'll be a breakthrough moment. We can talk about gun safety with credible voices on both sides. And Mr. Canterbury, while on the subject, thank you for the First Step Act. The endorsement of the Fraternal Order of Police and criminal justice reform and prison reform was historic and meaningful and made a difference. It was also noteworthy that we had the support of the prosecutors, the criminal prosecutors across this country, and the support of the American Civil Liberties Union. Go figure. How many times has this bunch ever gotten together? Not very often, but I think we passed something historic as a result of that. And I just wanted to personally thank you and publicly thank you for the role that your organization played in it. Mr. Johnson, we're looking back on the history of Mr. Barr, things that he said, things that he's done. And I give a speech that people I've heard a few times now, but they were startled the first time I gave it. The title of my speech is, let me tell you about the worst vote I ever cast as a member of Congress. It was over 25 years ago, and I'll bet you know what it was. It was 100 to 1. Crack cocaine to powder cocaine. We were determined to stop this new narcotic in its tracks. It was super cheap. It was deadly. Pregnant women who got hooked on crack cocaine would give birth to babies with lifelong problems. And we came down as hard as we could, not just with 100 to 1, but mandatory minimum sentences on top of it. 3 strikes and you are out for life. And we hit them hard. And we watched our prison population explode, primarily with African Americans. I look back on it as a big mistake, one of the worst I ever made as a public official. And I've tried to rectify it. We passed the Fair Sentencing Act 8 years ago. We've now passed the First Step Act. We're starting to give to these men and some women a chance to start their lives again. So now we look at Mr. Barr, and some of the things he said were consistent with my vote and the votes of a lot of Democrats back in the day when we were getting tough on narcotics. And he was as tough as they get. He was writing books about building more prisons and putting more people in these prisons. He's continued in that vein up until the last few years. So I just want to tell you, I pray for redemption, both personal and political. Do you think Mr. Barr is entitled to a chance to redeem himself when it comes to this issue?
Thank you, Senator Durbin. I think any individual is entitled to redeem himself when they make a mistake. Our position on mass incarceration is just that. We've had a lot of individuals who've made mistakes, who should have been exonerated or not prosecuted to the extent they were. I grew up in Detroit, Michigan. I lived through the crack epidemic in the 1980s. I seen the damage it did, but I also seen many individuals who was thrown away for many, many years. And for an individual who's situated to acknowledge the history of what took place, and as you just done, say, you know, I made a mistake, that's a good thing. I have not heard that from the nominee. That's my concern. The other concern I have goes back to the exchange earlier, when we oftentimes conflate civil rights issues of democracy with partisan considerations. Ensuring individuals have access to the vote is not a partisan issue. It is an issue of democracy, and any AG should vigorously protect the right of individuals to vote, especially when over the last 2 years we've seen more tactics of vote suppression than we've seen in the last 25 years. Issues of equal protection under the law is not a partisan issue. It's an issue to ensure that all citizens of this nation are afforded equal treatment. And so our objection to Mr. Barr's nomination is not a partisan issue. It's not an issue of disagreement. It's an issue of concern as it relates to the mass incarceration and the vigorous prosecution that took place in the 90s. And whether or not we are considering a nominee who is still thinking in a 1990s frame, or are we looking at a nominee who's really looking at the First Chance Act and the progress that's been made?
I've only got a minute left, but I want to take it to that issue that you took it to, and I invite Mayor Morial to join in on this too. This question of election integrity has become a code word. When you hear election integrity from the other political party, it's about making sure that people who are not qualified and not legally eligible don't vote. And I don't think anybody disagrees with that premise. But there's something else going on in the name of voter integrity, and that is obstacles to voting that are totally unnecessary and really discourage people from using this right, which is fundamental to a democracy. When I held hearings on this committee in Ohio and in Florida and asked them about ID cards and early voting and said, what is the incidence of voting abuse in your state that led you to make it harder to vote? There were none. I think it's just a policy, a political policy, to fight demographics, to try to keep people away from the polls who may change the outcomes of elections. I didn't hear yesterday from Mr. Barr any commitment to voter integrity in the terms that you and I would probably discuss it, and that concerns me. I'm not sure I can expect to hear it under this administration. But, Mr. Morial, if you close.
I think there's something important about what you're saying, and I certainly point the committee to exit polls that took place after the 2018 election, wherein people were asked, do you believe that voter suppression or voter fraud was a greater issue? Voter suppression won the poll of the American people overwhelmingly. These are exit polls where the numbers were sort of 58 and voter fraud was down maybe in the 30s or 40s. That's number one. Number two, the Shelby case has done significant damage because it was post-Shelby that the shenanigans of voter suppression, of cutting back on early voting, on voter ID laws, on restricting groups like the League of Women Voters from conducting voter registration drives, really exploded. Some 40 states had proposals to restrict access to the ballot box. When I think about this, I think about it that we are waging war to, quote, promote democracy, Senator Graham, in Iraq, in Afghanistan. But right here on the home front, how can we countenance efforts based on no evidence to restrict access to the ballot box? The Shelby decision, I predict, will be seen in history the way Dred was seen, the way Plessy was seen, as a bad, ill-advised decision. We need, because what we're left with is the power of the Justice Department under Section 2. And under Sessions, not one single Section 2 case was brought, even though you've had this explosion of voter suppression efforts. So what we need is an Attorney General who says, I'm committed to the utilization of my Section 2 of the Voting Rights Act powers to enforce the Voting Rights Act. And I would certainly encourage that the nominee be asked his position on this, because this is so crucial to the protection of democracy, which is really what this nation is all about. Democracy and voting is at the foundation of our system.
Make a quick comment, and then Senator Kennedy. I'm glad you mentioned Iraq and other places where we're fighting to help people. There was an attack today on a restaurant. I think it's the same restaurant I visited with the Kurds and Arabs and others. and manage Syria to hold on to some representative government. And fortunately, I believe some American advisors were killed there by ISIS. So this is not the subject matter of the hearing, but I want to make a quick statement. My concern by the statements made by President Trump is that you had set in motion enthusiasm by the enemy we're fighting. You make people who are trying to help wonder about us. And as they get bolder, the people we're trying to help are going to get more uncertain. I saw this in Iraq, and I'm now seeing it in Syria. Every American wants our troops to come home, but I think all of us, the people over there, can't at least sit down and talk with each other. The only reason the Kurds and the Arabs and the Christians were in that restaurant is because we gave them the space to be in that restaurant. And you think what you want to about those people over there. They've had enough of killing. They'd love to have the opportunity we have to fix their problems without the force of violence. So I would hope the president would look long and hard of where he's headed in Syria. I know people are frustrated, but we're never going to be safe here unless we're willing to help people over there who will stand up against this radical ideology. And here's the good news. Very few fathers and mothers over there want to turn their daughters over to ISIS, their sons over to ISIS. They just need our help. So to those who lost their lives today in Syria, you are defending America, in my view. To those in Syria trying to work together, you're providing the best and only hope for your country. I hope the president will look long and hard about what we're doing in Syria. Senator Kennedy.
Thank you, Mr. Chairman. Pastor, I'm very, very sorry for your loss. I wanted to tell you that personally.
Thank you, sir.
Before I ask my sole question, which I'll direct to each of you to address briefly if you could, I want to do a couple of things. I want to give a shout out to my former mayor, Mayor Morial. Many of you know him as the president and chief executive officer of the Urban League, and I, of course, know him in that capacity as well, but I know him as our mayor in New Orleans and the head of the League of Cities and a state senator. We still claim him in Louisiana. I also want to recognize his sidekick, Senator Cravens, former state Senator Cravens. We miss him in Louisiana, too. I listened to the discussion we had about the scorecard that Chairman Graham brought up. I'm going to make one very gentle observation that it may be appropriate in other areas, including but not limited to the challenges we face with the shutdown. And that is that so long as all of us on both sides and all sides and of every political persuasion are drunk on certainty and virtue, it's going to be hard to make progress. We probably ought to listen more, talk a little less. Here's my question, and if you don't care to answer it, that's okay, or you don't have any thoughts. But I would like to know this. As you know, we have a Sixth Amendment right to counsel in America. It's part of our Bill of Rights. But in some instances, in too many instances, it's a hollow promise. And I'd like to know your thoughts about our public defender system in America and whether you think it comports with the requirements of the Sixth Amendment right to counsel. We'll start down here and just go down there, if that's okay. I would ask you all to be brief because I want everybody to have a chance.
From our experience, the public defender system is in dire need of assistance. It leads to plea bargains that may not, should have happened, and we would definitely support more money for right to counsel in the We don't take the backseat to anybody on your right to be represented, and the system's woefully underfunded.
Okay, thanks. Pass.
I believe our public defender office needs resources. Most of the people that receive a public defender are marginalized people without resources, and their opportunity to have the best counsel they have is not something they get. And I would want that office to be able to serve everyone, regardless of whether they have money or not.
Okay.
Senator, I'm particularly thankful for you to raise this issue. As a criminal defense attorney, I can tell you that the public defender system is an utter wreck. It is underfunded. Judges are sanctioning public defenders because they have too many cases and they can't get to court. And so public defenders are in this position where they can't handle all the cases, and yet they're held in contempt, but they don't want to do a case inappropriately without zealous representation. So they have this absolute impossible situation, and it's even worse on the state system. I gave a speech in Pittsburgh, and I sat down with some public defenders there. The public defenders in Pittsburgh that I had dinner with are all moonlighting as bartenders and waiters to try to continue to be public defenders and feed their family. I mean, that's how bad this system is.
Professor.
No, I agree that public defenders are heroic public servants, they're overworked, they're underpaid, and that the system of public defense and provision of counsel needs to expand far beyond even the limited area it applies to now, into municipal courts, into infractions that shouldn't but do end up leading to people serving jail time.
Senator, I'm the daughter of a criminal defense lawyer. I'm married to a criminal defense lawyer, and he's the son of a criminal defense lawyer. So I'm all in favor of great lawyering available for all Americans who find themselves in front of a courtroom. The thing that I would suggest is I'm aware here in Washington of many law firms who are partnering pro bono with criminal defense, public defender services to try and get young people in court and get them great experience while also giving good representation to people who need it. So maybe that's one of the answers that you can look into, but my understanding is they need all the help they can get, and maybe young people can help.
Thanks, Professor.
Couple of quick things. I had the great privilege and pleasure last year to speak in Atlanta to the Federal Public Defender Service at its convening and gathering, and I would offer to the committee perhaps this as an example of a bipartisanship oriented initiative, which is this committee to hold hearings, do an examination of both the federal public defender system, which may be in a little bit better shape but underfunded and understaffed, as well as local public defender systems, and you'll get a real sense of what everyone has said, how stretched, how overworked, and how, in effect, damaging this is to the operation of justice and to the constitutional guarantee of the Sixth Amendment. Now, the last thing I'd say, in the late 80s, Senator Kennedy, I was part of a small group of lawyers that actually challenged the very same issue in Louisiana. We challenged it by asking the state Supreme Court to conduct an investigation, which they did. They found that the system was underfunded, but then they took the position that as the Supreme Court, they could not, quote, instruct the executive branch to adequately fund the public defender system. Bottom line here, I would offer this, and I'm glad you raised it, as an important element of this discussion around criminal justice reform, and that is to repair, to fix, to reform the public defender systems, both at the federal, at the state, and also at the local levels across this nation.
Thank you, Mayor.
Thank you, Senator Kennedy, for raising this issue as someone who served on the board at one time of the Atlanta Federal Defender Program. I think the public defender program definitely at the federal level needs strengthening. However, at the state level, it is a total collapse. And I think what the Department of Justice can do, and you could pursue this with Attorney General nominee Barr, is through the Office of Justice Programs, encourage OJP to develop programs to assist state public defender offices, appropriate funds for that purpose in terms of grants, because the Department of Justice is not the Department of Federal Prosecution. It's the Department of Justice. Thank you.
Certainly agree with the panelists today that the public defender system is in dire need. I served as a commissioner on the State of Mississippi Access to Justice Commission, and we reviewed this issue. Mississippi is one of the poorest states, similar to Louisiana, and what we found was a system so corrupt, it was one of the primary factors for prison overcrowding. You have a large number of individuals who are sitting in jail as pretrial detainees because they have ineffective counsel or no counsel at all. So it's an issue that I agree with my colleague, Marc Morial, that this could be a bipartisan issue we can work on because the need is definitely there.
Judge?
Senator, my experience, I think, is probably more limited than virtually the experience of all of the other panelists because my experience is largely confined to one district in the United States.
Right.
That said, my experience with federal defenders in the Southern District of New York was that they were people of unparalleled skill. There was competition to get those jobs, and they were highly valued. Similarly, under the Criminal Justice Act, we appoint private lawyers to represent defendants. Again, there's competition to get on that list, so you really get the lawyers, by and large, in my court, who represented indigent defendants were, by and large, more skillful, in my experience, than the privately retained lawyers, some of whom were simply showboats. That said, I think the system is definitely in need of support, certainly at the state level, and I second Larry Thompson's call for having OJP target particular areas with grants so that there can be demonstration projects that would show the way.
Thanks to all of you. You honor us with your time and your testimony today.
Thank you, Chairman, and thank you very much to the panel, particularly Reverend Risher. I'd like to join my colleagues in expressing my appreciation for your testimony here. I had the opportunity nearly 3 years ago to visit Emanuel AME Methodist Church with the Faith and Politics Institute. It was one of the most moving experiences of my life. It was remarkable. And to meet with the survivors a few months later here in Washington was impressive. And I'm so glad that you are keeping that tragedy alive in our hearts because it should not be overlooked, and I appreciate it.
Thank you, sir, for your words. And the Emanuel 9 will be something that I will continue to talk about their lives to let other people know that they did not die in vain. And I thank you for your comments.
Don't ever stop.
Thank you.
Mr. Mukasey, I have some questions for you, and I want to let you know right off the bat that this goes back about 10 years. And so you will have full, I will give you every chance to answer more fulsomely in written answers, you know, question for the record, so that if there's anything that you don't recall now. But the reason I wanted to ask you your questions is that I view it anyway as a responsibility of the Attorney General to fearlessly go where the evidence and the rule of law lead, and to allow, particularly in investigative matters, to let the evidence and the law be your guides. Now, given the circumstances that surround the department, the willingness of an Attorney General to be independent where evidence leads to the White House is of, I think, particular moment. And that takes me back to the investigation into the removal of 9 U.S. attorneys in 2006. That report was concluded in 2008 on your watch as Attorney General. As you'll recall, it was a joint effort. Those don't happen all that often in the department, but this was a joint effort between the Department of Justice Office of Inspector General and the Department of Justice Office of Professional Responsibility. And the investigation led both into White House files and into Office of Legal Counsel files. As to the White House files, the White House refused to cooperate and refused to provide access to your OIG OPR investigators to close out their investigation. The OLC refused to provide unredacted documents to members of their own department. The report that was issued in 2008 indicated that the investigation had been, and I quote it here, hampered and hindered and left with, quote, gaps as a result of the failure of the White House and OLC to provide